My name is Chandrapala from Armchair Criminal. This is a knowledge sharing platform, and I welcome you all to this part of the program. In this part of the program, we will be considering hearsay evidence from unavailable witnesses. Section 116 is designed to deal with witnesses who are unavailable and to adduce their evidence through this exception, or the gateway as some would refer to it as. In order to admit the hearsay evidence, at least one of the conditions of subsection 2 should be met. There are 5 conditions in subsection 2. At least one of them should be established. Admitting hearsay evidence from an unavailable witness is not always automatic. However, if the party applying to adduce the hearsay evidence can establish one of the conditions A to D to the satisfaction of the court, then the court leave is not required. However, when it comes to exception E, which is through fear, the court's leave is required. Not only that, those who make applications under Section 116 should be aware that there are competing human rights issues, right to a fair trial issues could arise and would arise very often. They have to be ironed out. That is where the court will become really involved. We will look at very briefly in this part of the program the concept of sole and decisive evidence, but much of it will be explored in detail when we look at the application of human rights and right to a fair trial in the light of hearsay evidence. That is a completely separate program in itself. But briefly we will mention it here. The importance of this provision should not be underestimated. This is particularly useful tool and very often used by the prosecution. And there could be overlaps between Section 116 and other parts of the section. Therefore, one can understand this part of the program under unavailable witnesses is a huge topic. I do not propose to deal with everything in this single sitting. Therefore, what I propose to do is to break this topic into 4 parts for your convenience. But you can expect the 4 parts to be uploaded and made available to you in quick succession. So let's start off by looking at, in summary, what are the characteristics of Section 116 of the Criminal Justice Act with regard to hearsay evidence. I have identified 11 characteristics. 1. The maker of the statement identifiable. 2. Different standards apply. 3. There could be an overlap between section 116 and other sections. We will look at that. 5. Conditions in this section. That's the 4th point. One of the conditions must be met. The 5th point, it must be admissible. 6th point, the maker must have the capability. That's the 6th point. 7th point, the maker must have the capacity. The 8th point, it must be first-hand hearsay. Next, section 116 could be pleaded in the alternative or even could overlap with other sections. Leave of the judge may be required. 11. The opposing party could object. So now let's look at these 11 points a little bit more detail. The first point that I mentioned is the maker of the hearsay statement should be identifiable. Why? Otherwise, that person remains an anonymous witness. When we look at the legislation in close detail, you will notice the section actually specifies that. Then, second point is different standards. If the application is made by the prosecution, make sure that you put them to prove their case on this issue to that high criminal standard. 3. Third point. The hearsay statement could have been made orally or in writing. If it was made in writing, a written statement, then section 117 might come into play. For example, very often you will get a CRIS report. There will be material that you may want to adduce. It may be feasible to make a section 117 application, or in the alternative, section 114. Or if it was oral evidence, the officer is there, and this is then under section 116. Equally, section 118 might come into play. Imagine the case, if I recall case, it was the case of Subramaniam. It would very easily be a case where res gestae applies. Therefore, it may be the only evidence, like in a fatal stabbing. The last words of the deceased may be the only evidence as to who did what. Therefore, section 118 could come into play. Sorry, what I meant is Chandrasekhara. Chandrasekhara is the case where a person was the person died after the throat being slit, and the victim just before the death gave the name of the defendant. Now that's a classic example. One would say res gestae could come in. as well as Section 116. If the only witness to the incident is the victim, now who has died, then it will be so unfair, at least not to consider that part of the evidence under Section 118 and doing the alternative 116. Remember that also comes within the definition of the person is dead, which we will look at as one of the conditions. Then the next point is the evidence under Section 116 must come within one of the five categories. They are basically the person is dead, unfit, unavailable, out of the jurisdiction, fear, which we will look at in detail, and the procedure for it being adduced. Next point is the maker of the hearsay statement should have had the capability, followed by the capacity. Here what we mean is mental capacity. The hearsay statement to be adduced, it should also be the first-hand hearsay. Otherwise, we generally have a problem, hearsay upon hearsay being adduced. It can be done, which we will look at as a separate topic at a later date. But it should be first-hand hearsay. At least the argument becomes weaker if it is not first-hand hearsay. Leave of the judge is required. Certainly under category E, which is under fear. As for A to D, the court has to be made satisfied to that high standard that one of those conditions do come into play. If it is done, then leave is not needed, but as part of that, it may be the judge will look at other issues, sole and decisive. For example, the circumstances what led to the situation. Then Section 114 could be pleaded in the alternative. Section 114, in the interest of justice, is a separate topic in itself, which is a separate program, but we will look at it. And the opposing party could object to the material being adduced. Now, let's look at what the legislation says. Trust me, if you want to understand how this part of the legislation, or for that matter, any part of the legislation, be it Criminal Justice Act 2003 or anything else, you got to be able to analyze it. Whilst I accept that it could be like watching paint dry, it is important to analyze, so I'm going to do it with you. Section 116, Criminal Justice Act 2003. Subsection 1, we'll go from there. What it says is as follows. 1. In criminal proceedings, a statement not made in oral evidence in the proceedings is admissible as evidence of any matter stated if a. Oral evidence given in the proceedings by the person who made the statement would be admissible as evidence of that matter. B. The person who made the statement, i.e. the relevant person, is identified to the court's satisfaction. Remember, we looked at the 11 points. This is one of them. You have to be able to identify the person to the satisfaction of the court. Any of the 5 conditions mentioned in subsection 2 is satisfied. You would note I alluded to this situation earlier when we looked at the 11 points that I mentioned. Now we go on to consider section 116, subsection 2. A. That the relevant person is dead. No problem. Well, it is a problem, the person is dead. But it's straightforward, basically. B. That the relevant person is unfit to be a witness because of his bodily or mental condition. Unfit means it's bodily or mental. If the person is bedridden, then may very well be that the person is unfit. Equally, if the person is unable to even have a conversation because of the mental conditions, health issues, then that person may not be fit. C. That the relevant person is outside the United Kingdom and it is not reasonably practicable to secure his attendance. One of the problems we have in this jurisdiction is we don't have a mechanism to bring witnesses from other jurisdiction because you can't seek extradition. That is not what extradition is for. It is a difficulty that we have. However, if the person is willing, not physically able to travel to our jurisdiction, would not be a problem, especially these days with COVID. Some countries don't allow people to come in. Some countries don't allow people to leave. So it could be a problem. However, where the person is willing, then there is room to maneuver, which we will look at. But that is by way of through a live link, basically. D. That the relevant person cannot be found, although such steps as it is reasonably practicable to find him have been taken. Now, this is important. Under C, where the person is outside the Union, not reasonably practicable, here practicable steps have been taken. E, that through fear, the relevant person does not give or does not continue to give oral evidence in the proceedings, either at all or in connection with the subject matter of the statement, and the court gives leave. This is why I said the court gives leave. Remember, the other conditions did not mention the court giving leave. It's here rather for the statement to be given in evidence. Now, it will be interesting for us to look at what fear is, which we will look at, and that is likely to happen on the 4th part of this 4-part series on unavailable witnesses. Then the next is subsection 3 and 4 of section 116. For the purposes of subsection 2e, fear is to be widely construed and, for example, includes fear of the death or injury of another person or of financial loss. There you are. You know now it is being defined quite wide. It need not be the witness he himself is being threatened. Could be a family member. That is why it says death or injury of another person. Then it goes on to talk about financial loss. Basically, a blackmail. You come and give evidence, your business will be ruined, kind of a thing. That is sufficient. Subsection 4. Leave may be given under subsection 2e only if the court considers that the statement ought to be admitted in the interest of justice, having regard A, to the statement's content. What does it say? How important? B, any risks that its admission or exclusion will result in unfairness to any party to the proceedings, and in particular to how difficult it would be to challenge the statement if the relevant person does not give evidence. There the court will look at not only the admissibility, but also the exclusion, the effect of it. Weigh it up. How unfair it would be to any party. If the prosecution is applying, the defense is objecting, to exclude it, it could be unfair to the prosecution. Equally, to admit it, it could be unfair to the defendant. And how difficult it is to challenge. See, in appropriate cases, to the fact that that direction under section 19 of the Youth Justice and Criminal Evidence Act, special measures for giving evidence by fearful witnesses could be made in relation to the relevant person, and D, to any other relevant circumstances. This is a possibility. If the person is in fear of giving evidence, it may be those fears can be alleviated if one could put certain mechanisms in place, like giving evidence behind a screen or through a video link. Next, what we are going to look at is subsection 5. A condition set out in any paragraph of subsection 2, which is in fact satisfied, is to be treated as not satisfied if it is shown that the circumstances described in that paragraph are caused A, by the person in support of whose case it is sought to give the statement in evidence, or B, by any person acting on his behalf in order to prevent the relevant person giving oral evidence in the proceedings, whether at all or in connection with the subject matter of the statement. That's a mouthful. What it is trying to say is this: no one can basically profit from their wrongdoing. Condition under E is not made even if it can be established. That condition is inexistent, but if it was caused by the person who's trying to adduce that very piece of evidence. This is where the case of Rowley will come into play, which we will look at the end of this part of the program. So, what we are now going to look at is how to invoke Section 116. How does the Section 116 get invoked? Answer is if the material is admissible evidence, i.e. not tainted. B, the maker of the statement which we looked at has the capability and the capacity. Remember, I put them in red brackets. This is what I'm talking about. This is why I said you have to be able to analyze the section. The person must be competent. This is where I talked about the spouse, the diplomat, who may not want to give evidence. Then we got to look at the relevant person concept. Any of the 5 conditions in subsection 2, then would we require the learned judge's leave to adduce hearsay evidence. Now, looking at taking things in turn, what is meant by admissible evidence in Section 116, subsection 1A? It must be legally admissible. When we talk about legally admissible, what we mean is that it is not tainted. If it is tainted, for whatever the reason, or if the person has no capability, including capacity, then the evidence should be excluded. And this can be done either under Section 78 of PACE or under Section 126. If the person didn't have the capability, then you could make an application under Section 123. That is what I'm dealing with on this slide. How many ways in which the evidence could become inadmissible. So the first point is, if the evidence is tainted, exclusion under Section 126 or 78. If the maker of the statement didn't have the capability, then Section 123 could come into play. Let's look at Section 126, tainted evidence. Question: how Section 126 Criminal Justice Act can be applied to exclude the evidence? The answer is Section 126 of the Criminal Justice Act 2003 gives the judge, the court, a general discretion to exclude hearsay evidence. Subject as evidence of matter stated if A, the statement was made otherwise than in oral evidence in the proceedings, and B, the court is satisfied that the case for excluding the statement taking account of the danger that to admit would result in undue waste of time. This is where we talk about satellite litigation. Substantially outweighs the case for admitting it, taking account of the value of the evidence. If it is pretty insignificant, if it is on the fringes of the main case, judges are not going to allow the court to take inordinate amount of time dealing with a side issue, what we call satellite litigation, because it could not only waste time, it could divert the jury's attention from the main point, lose focus. So the judge will be keen to keep things in track. Subsection 2. Nothing in this chapter prejudices A. Any power of a court to exclude evidence under Section 78 of Police and Criminal Evidence Act 1984, exclusion of unfair evidence, or B. Any power of a court to exclude evidence at its discretion, whether by preventing questions from being put or otherwise. We go on to consider how would Section 126 would operate. This is how it looks. The application of the law. Evidence to be excluded if obtained in breach of rule of law. What it really means is, if the evidence was gathered in breach of proper investigative procedure, that could affect the admissibility of evidence. For example, if you are looking at cases of breach of pace, improperly obtained evidence, or could be breach of RIPA or IPA. RIPA is Regulatory Investigation Powers Act, IPA is Investigative Powers Act, where telephone messages and everything is tapped, where covert human intelligence is used, what is called chase. Then it may be possible to apply to exclude the material. Then the Crown or the co-defendant could make an application under Subsection 1A and B and 2 of the Criminal Justice Act 2003. Section 126, Additional Exclusionary Rule, the burden of proof and the judge's leave should be considered now. How can Section 126 operate? Let's look at the situation in this manner. Example, the defendant can make an application to exclude the prosecution evidence which was obtained in breach of pace, which I mentioned earlier, or covert recordings under RIPA or IPA. If it is an application the Crown or the co-defendant wishes to make, then application under Subsection 1A and B and Subsection 2 of Section 126 could be made. Classic example of this would be where the co-defendant's spouse implicates A, her husband, say, and exonerates B, the co-defendant. The wife no longer wishes to give evidence against A. Therefore, the wife no longer wishes to come to court. Co-defendant B wishes to make an application to adduce A's wife's out-of-court statement. Then A could apply that statement to be excluded. What is also important to note and remember is that hearsay evidence is inherently subject to the exclusionary rules, unless an exception can be found. Therefore, Section 126 is in addition to the existing exclusionary rules. Consequently, the party seeking to adduce the hearsay evidence bears the burden, and the judge's leave could be needed before the evidence can be adduced. Here, in particular, Section 116, Subsection 2E, i.e. fear. In the case of Red, 2012 case, the court said the starting point, that is, the necessity for resort to second-hand hearsay must be demonstrated. This is why I said right at the beginning that if it is hearsay upon hearsay, it becomes weaker. And went on to say that detailed examination should be taken where the application is under the gateway of the witness's unavailability through fear. The court will go into detail. Therefore, based on the authority of right, it would be safe to think, I should have thought, that hearsay upon hearsay is unlikely to be admitted easily. Now we are going to look at capability of the statement maker. Is there any other reason as to why that the evidence may not be admissible? Yes, the capability. Why is it the capability of the statement maker needs to be established? Section 123, subsection 3 defines for this purpose as the purpose of this section. When you look at section 123, it reads as follows. Subsection 1, nothing in section 116, 19 or 120 makes a statement admissible as evidence if it was made by a person who did not have the required capability at the time when he made the statement. Subsection 3, forget about subsection 2 for the time being. For the purposes of this section, a person has the required capability if he is capable of A, understanding the questions put to him about the matters stated, and B, giving answers to such questions which can be understood. So the issue of capability is determined by questions put to the person and the answers that the witness gives. Now there's an interesting point here. In my view, there's a problem. Before we look at that problem, it is important to understand how capability is dealt in this section. The only definition of capability is in subsection 3, which says, for the purposes of this section. In other words, for the purposes of this section, understanding the question, being able to answer. That's all. Okay? Therefore, the definition given is applicable to the entire section 120 in section 123 to assist in the interpretation of section 116. What is the definition of capability? That is in section 123, subsection 3 and B. Defines capability as being able to understand questions which I explain and answer. Therefore, this is the conundrum that I have. What capability means is to understand and answer. Consequently, it must mean the capacity. In other words, does the witness, the statement maker, did that person have the capacity? If I am right, if capability equals capacity, is there a difficulty in this legislation, this part of the section? That's the question I ask myself. And I come to the conclusion that there is. Because Mental Capacity Act 2005 is in conflict with section 123 Criminal Justice Act 2003. The problem occurs, Mental Capacity Act 2005 superseded Criminal Justice Act 2003. Remember 2003? Criminal Justice Act, Mental Capacity Act 2005. Why do I say that there is a problem? Because when you apply strict rules of interpretation, the new legislation is deemed to supersede the previous legislation. According to the Mental Capacity Act 2005, as human beings, we all are deemed to have capacity. We don't need to establish. It is a deeming provision. So we have a situation where the Mental Capacity Act deems the maker of the statement to have had the capacity. Yet, the Criminal Justice Act 2003 says he must have had that. So that is a part that you have to establish. That is where the conundrum is. I must confess I have not been in this situation to say what the outcome would be. And I would have thought that the court will say this is a requirement in Criminal Justice Act 2003, but it is in conflict with Mental Capacity Act 2005 and Mental Capacity Act possibly should override Section 123. Therefore, the legal burden would revert back to the opposing party to show the maker of the statement didn't have the capacity. What is the difficulty in applying Section 126, which I just described about Section 123 being superseded by Section 1, Subsection 2 of the Mental Capacity Act? And if the burden of proof is shifted to the opposing party, how on earth are they going to challenge that? Because the whole purpose of Section 116 is the witness is not available. So how are you going to assess someone's mental capacity when that person is unavailable? Is not something I would like to take on. Now, we are going to look at who and how the issue of capability is determined, which I said that at the beginning we will have a look at. The answer is it is the judge under Section 123, Subsection 4 of the Criminal Justice Act. It reads as follows, Subsection 4. Where by reason of this section there is an issue as to whether a person had the required capability when he made a statement. A. Proceedings held for the determination of the issue must take place in the absence of the jury, if there is one. So this is a legal issue. Send the jury out, deal with it. B. In determining the issue, the court may receive expert evidence and evidence from any person to whom the statement in question was made. So you can submit expert reports, and the person who received it may be able to say, this was the mental state of the person who made the statement. C. The burden of proof on the issue lies on the party seeking to adduce the statement, and the standard of proof is the balance of probabilities. Now, again, I have a difficulty there. The difficulty is this. As we looked at, that particular subsection is in complete opposite to the requirements of Section 1, Subsection 2 of the Mental Capacity Act. And it goes on to say, it's on a balance of probabilities. So does it apply to the prosecution too? When they have an overall duty to establish their case to that high standard which we always look beyond reasonable doubt, or sure, however you want to put it. That's the situation. So this is something that one must be careful of. Now the next, and I believe this is the penultimate slide in this part of the program, is what about those witnesses who can claim a legal privilege in refusing to give evidence, therefore taking them outside Section 116, such as a spouse or a diplomat. In other words, where the witness is competent but not compellable. Look at Section 116. Section 116 does not apply to a spouse who says, I'm not going to give evidence against my husband. The person is available, he's just refusing. That is my right. I have a shield on that. Unless, of course, it's a domestic violence, or that's a whole other list of offenses like cruelty to children or sexual offenses. That's different. But let's take, for example, this is a drug case or a robbery, completely outsider. The wife can. Equally, a diplomat can. So Section 116 doesn't apply. However, if the spouse has made a statement, then that statement could be admissible. She may not be able to be called to give evidence, but the statement that she made outside could be made, and that could be adduced. Not under Section 116. The application might come under Section 114 in the interest of justice. Now compare that to the case of Ravi. Ravi is a case where a murder took place, and there were 3 people, one of whom got interviewed. In fact, they all did, but the person that we are concerned got interviewed, and eventually he was told he is not going to be charged. 2 people got the appellant, and another person got charged. They went to trial, and the person who didn't get charged described what took place, and he received threats from the appellant. Eventually, it is believed that he may have gone to Spain, and the prosecution wanted to adduce that person's interview under Section 116, under the category of E, fear, because threats were made. But in the meanwhile, the defendant served a defense statement, hallelujah, his presence at the scene. Then the defense thought, before that, the prosecution actually abandoned their application to adduce the interview, because in the defense statement he spelled out, yes, I gave him a punch, but nothing like what is described against me. So they were fairly confident that the interview of the missing witness is no longer needed. The defense thought that could help them and made an application. Judge refused it. Remember when we analyzed the evidence? When we analyzed the legislation, this section, that we talked about, you cannot profit from your own wrongdoings. Here the judge said, I'm convinced that the person is unavailable because of the fear, and didn't allow the defendant to adduce the missing witness's interview. We will look at this again when we deal with admissibility of hearsay evidence under exception E, which will be in the last part of this program. That is all I intend to discuss at this stage in this part of the program. I hope you will join me again for the continuing parts of hearsay evidence from unavailable witnesses. I trust that you found it useful and enjoyed it. Thank you very much for your time. God bless.